In August 2025, a federal court order set a deadline, and the deadline was this: destroy the files, everything recovered from Michael Proctor's phone, the images, the messages, the decades of texts, was scheduled to be legally deleted with a judge's signature on it. And the reason is the federal investigation had formally closed. And when the federal case closes, the evidence retention order expires. And the Norfolk County prosecutors told the court, so we have the documents. We cannot review them, we cannot release them without a separate federal court order, and our hands are tied. So, active state murder case, materials held by prosecutors, federal court order about to delete them, and the prosecutors could not legally do anything about it. One attorney representing a Brian Walsh defense ran into court, emergency preservation motion, last minute, and the judge, Peter Krupp, intervened, ordered the U.S. attorney to retain. And that's it. That's a margin. And one attorney, one filing, one day. And if that motion doesn't get filed, everything you're about to hear, the decades of racist text messages, the images of women who had no idea they were being shared, and the content, and an attorney described in open court as staggeringly anti-woman, racist, homophobic, and antisemitic, and gone legally, permanently now. Let me tell you what's actually in that phone. And more importantly, let me tell you who received it. This is not a recap video. If you want, here is what happened in the Karen Reed case. There are 200 of those. What I want to do today is a different thing. I want to show you a structural argument. The one that survives acquittal, survives sealed records, and survives every attempt to contain it. Michael Proctor's cell phone is not a story about dirty cop. It's a documented, court-authorized, judicially described liability bomb sitting underneath every murder conviction he touched going back to 2013. And the people fighting hardest to keep it sealed, some of them are in the messages. Quick standard of proof note before we go further. Everything I described today comes from one of three places: court filings, attorney arguments made in open court, and a sworn testimony on the record. Not podcast, not Reddit, not sources say. And if an attorney said something in a court before a judge, that's an operating standard here, and that's what I'm working from. And notably, nothing I'm about to describe has been denied under oath. With that, let's go. April 23rd, 2026, Norfolk Superior Court. Karen Reed's attorney, Aaron Rosenberg, stands up and tells Judge Michael Doolin that Proctor's messages are, in direct quote, staggeringly anti-woman, racist, homophobic, and antisemitic, among other things. Those two words are doing an enormous amount of lifting for a low degree. Defense attorney Rosemary Capiccio, hope I pronounced it right, fills in specifics. She tells the court Proctor wrote things like, "It's a killing word in Canton Day," and that's a paraphrase, and that's what an attorney told the sitting judge in open court. And other content confirmed or described in court filings and attorney arguments, and images of women intimate body parts, and a woman who were not parties to any investigation described less likely unaware that their images had ever been shared. And a sexual assault victim name on a personal phone, and a private phone numbers, and a personal mail addresses, and a screenshot of Facebook profiles. And here is the single most viral sentence in the entire case. Capiccio described Proctor sharing violent, racist, misogynist content with friends, family, colleagues, and supervisors. Like it, please pass the butter. Not hidden, not encrypted, not a guilty secret he kept for himself. Passed around casually to the people he worked with every day. The phone data spans 2013 to 2022. Not one bad year, not a rough patch, 9 years. And here is what Proctor himself said about his own conduct through his own attorney's mouth at the Civil Service Commission hearing. Distasteful, unprofessional, inappropriate, juvenile, sexist, disgusting, dehumanizing. And his attorney read all 7 of those words out loud in a legal proceeding. And that's a defense. Now stop. Because this is where every recap video misses the actual story. Everyone focuses on Proctor. Proctor's texts, Proctor's bias, Proctor's firing in March 2025. But Capiccio was not just describing Proctor's messages. She was describing who he sends them to: friends, family, colleagues, and the supervisors. If a supervisor just received, an officer receives misogynic messages with casual frequency of daily conversation, and it does nothing. That supervisor is not bystander under federal civil rights law. They are defendant. And the Karen Reed's attorneys already named two of them, Sergeant Yuri Buchanan, Detective Brian Tooley, and the November 2025 federal civil rights complaint doesn't say they should have known. It says they knew at all times exactly the extent of Proctor's misconduct in investigating Mr. O'Keefe's death, and at all times not have been aware, not were on notice at all times. Now, here why Judge Buchanan is already halfway into the deposition trap. He testifies under oath at retrial, May 9th, 2025, that Proctor texts were unfortunate and unprofessional. So, same testimony, same breath, and Proctor handles the investigation with integrity. He said both of those things back to back in a courtroom. And now, there are also this. Buchanan testifies he himself had been disciplined over misconduct allegation linked to Proctor, and the supervisory chain Reed suing wasn't just aware of Proctor's conduct, it was already sanctioned for it. Under civil discovery, unfortunate and unprofessional is not going to survive a plaintiff's motion for summary judgment. So let me do something that most coverage won't. Let me make the best possible argument for keeping the phone sealed, because one exists. The sealed content includes images of third-party women, private citizens who had no involvement in any investigation, who have an obvious legitimate constitutionally grounded privacy interest in not having their images released publicly. That's real. There are individuals who exchanged messages with Proctor, who haven't been charged with anything, may never have been charged, and whose lives could be upended by an indiscriminate public release. The current protective order framework threads that needle. Reed's attorney can use the materials, so the defense team in related cases receives them, and the general public doesn't get a document dump, targeted disclosure, and not public spectacle, and that's a defensible position. Hold the standard, because I'm about to show you Canton applying in a way that it's itself alive. And the Canton police sergeant Sin Goat placed on a paid leave on October 24, 2025, and the town's own public statement said the misconduct was discovered during an investigation into a former member of a different law enforcement agency, and they didn't name a Proctor. There is no other candidate. And on April 23rd hearing, Reed's attorney told the court the staggeringly anti-woman, racist, homophobic, antisemitic description and applied not just to Proctor, it applies to Good's own messages. And Good, who was among the first officers to respond to John O'Keefe's body, who testified at Reed's first trial, and who is by multiple court descriptions Proctor's close, long-time buddy. And Reed's attorney subpoenaed Good's internal affairs files, and the Canton response, and too broad, not relevant, doesn't relate to O'Keefe's death. So let's run the logic they are relying on. If the argument is privacy, a confidentiality restricted disclosure to Karen Reed's counsel satisfies the interest. But Reed's attorney had already agreed to confidentiality restrictions before Canton refused, and the privacy was not an issue. If the argument is irrelevance, why has Good not been fired in 7 months? No timeline, no public updates, no end date. A cop who exchanged messages described in open court as staggeringly racist and antisemitic with a lead investigator in a murder case is still Canton police employee on a paid leave. So there is a word for fighting the privacy argument while refusing disclosure to parties who already agreed to confidentiality. And Reed's attorney used a different word. They called it disingenuous. And under civil discovery, the standard that now applies to Reed's MSP lawsuit, disingenuous is a polite version of what this looks like when a deposition starts. And you're thinking one thing. I know you are. And she was acquitted. It's over. But what does any of this actually change? That's the right instinct. And here is why it's actually strong. Reed's acquittal ended the criminal case. It started everything else. Once acquitted, she gained standing to sue. And the November 2025 federal civil rights case targeted the individual's defendants. And the new MSP lawsuit, authorized April 27th, Earliest filing date, May 21st, 2026, and targets the institution itself. And the civil discovery is not a criminal discovery. And in criminal cases, prosecutors control what gets disclosed. But in civil litigation, its attorney subpoenaed internal affairs files and the supervisory communications and the hiring records and the command level emails and everything the criminal case couldn't reach. And here is a moment that deserves 20 times more coverage. The witnesses who sued Reed for defamation, Jennifer McCabe, Brian Albert, and Colin Albert, and Brian Higgins, filed that complaint on April 15th. And the Reed team called it desperation on the page, and the Turtle Boy attorney called it a gift, because a civil discovery runs both directions. The witnesses who spent 4 years managing what could be assessed about their phones, finances, and communications just handed Reed's team the right to subpoena all of that. 4 years trying to control discovery and one lawsuit. You cannot make this up. One other chaos element nobody is tracking closely enough. The prosecutor assigned to Turtle Boy's separate witness intimidation case was forced to withdraw after he was implicated in the Reed's civil suit. And the case now sits effectively without a prosecutor in a legal limbo for a month, and the Turtle Boy's attorney called his client stateless. And I had to include that, stateless. Every new development in the defamation suit now cross-pollinates with a witness intimidation case. And these aren't just separate storylines anymore. They are the same lawsuit eating itself from both ends. So let me give you the number that puts all of this in a context. 2013. That is how far back Proctor's phone data goes. Every murder investigation he touched from 2013 to 2022 is now credibility challenged, waiting to be filed, and currently active defendants receiving Proctor disclosures, like Merlin King, charged with 2021 murder in Milton, and his attorney Scapiccio said she is confident the materials will support a motion to dismiss, and Sean Johnson, 2022 murder charge, also receiving disclosures, and Giovanni De Los Santos and Bianca Cioncio and Brian Walsh, convicted December 15, 2025, of murder and disseminating his wife Anna. And the Walsh case officer was Proctor. The prosecutor decided not to call Proctor as a witness because his credibility had been so destroyed in the Reed's case. And the Walsh defense team spent months fighting for access to Proctor's files and the grand jury testimony and disciplinary records, and they received a limited subset. His appellate team now has the documented grounds to revisit every discovery ruling on the materials they didn't get, and convicted and this is over are not synonymous. And a Suffolk University law professor, Dion Bourne, put it directly: if Proctor acted improperly in one case, there is a reason to believe he may have been done so in others. And while reopening closed cases after a deadline is difficult, it's not impossible when new forensic disclosures constitute newly discovered evidence. And one more layer, and pay attention here, because this is almost completely absent from coverage. In March 2026, FBI testimony in federal trial confirmed that investigators successfully recovered deleted signal messages and from the phone's push notification database, and even after the app was uninstalled, because App Store's notification previews in internal memory and Reed's phones are being extracted under a joint stipulation that explicitly targets signal messages and deleted records and factory resets and boot events. The FBI technique for recovering deleted signal messages is now publicly documented, and the people who thought deleted messages meant gun may want to revisit that assumption, and there is also a structural irony here that most coverage completely missed. The DA's warrant to extract Reed's phone was denied in February 2026, and a judge ruled policy seized them without authorization to search, and the prosecutors appealed and filed a last-minute motion to stay the denial. And then the O'Keefe's family civil attorneys negotiated directly with the Reed's team and agreed to the extraction jointly, and the prosecution couldn't get a court to authorize searching Reed's phones. So the family lawsuit achieved the same result, though a consent agreement and that a workaround is sitting in plain sight in the joint stipulation, and most of the media hasn't noticed. Now I want to talk about the man who was supposed to be the institutional check on all of this, Norfolk County DA Michael Morrissey. On August 2025, NBC Boston publishes more than 4,000 pages of emails from his office, and some of them sent from his personal email account. And one message Morrissey writes to the Massachusetts Speaker of the House requesting over $1 million in additional state funding, specifically to prosecute Karen Reed. A sitting DA writing to a state legislator requesting public money for a prosecution his office chose to bring against a defendant who was later acquitted. The $1 million ask is interesting. The personal email is interesting, but here is the part nobody is connecting. Morrissey's office also handled the original investigation into Sandra Birchmore, and Birchmore died in 2021, and the former Stockholm police officer, Matthew Forwell, was later arrested for strangling her, and she had to tell people she was pregnant with his child. An original investigation classified her death as a suicide, and on April 2026, federal prosecutions disclosed in DA evidence and linking Forwell to her murder. And same DA's office, same tenure, two cases, and one where the wrong person was indicted and prosecuted for years, and one where the actual suspect was cleared as a suicide for 4 years. And Morrissey announced in January 2026 he would not seek re-election. The DA race, his exit record, is explicitly about both cases. Every declared candidate is positioning on Reed and Birchmore as the two defining issues, and his successor inherits every piece of litigation in motion: the Reed civil suit, the MSP lawsuit, the Birchmore prosecution, and the DA-owned email subpoenas. Whatever that office releases next comes out under next leadership. And think about what that means for whoever wins that race. We started with a federal court order about to delete everything. Let me close that loop. Here is the operational detail. Most coverage missed completely. The reason the files were targeted for deletion is that a federal investigation had formally closed. When federal case closes, the retention order expires. And Norfolk County prosecutors told the court, we have the documents. We cannot review them. We cannot release them without a separate federal court order. An active state murder case, materials held by state prosecutors, and state prosecutors legally prohibited from reading their own evidence. That's a sentence that should never existed in a functional legal system. And a Walsh defense attorney got there in time. Emergency motion and a judge Krupp intervened. And if that motion doesn't get filed on that specific day, the images of women who didn't know their photos were being shared, the decade of racist texts sent to supervisors and passing butter at breakfast, as a content that is now Exhibit A in a federal civil rights suit, as MSP institutional lawsuit, and 5 active murder defenses gone, legally, permanently, with a judge name on it. And I want you to think about what we almost never found out, and then think about what's still sealed. Because that is the actual story. Here is what's coming. May 21st, 2026, earliest filing date for Reed's lawsuit against the Massachusetts State Police as an institution. That complaint will be the most comprehensive legal document yet filed in a case, and every supervisory failure, every institutional decision, every commander-level communication with the Proctor's phone is an Exhibit A. And the Proctor himself filed a 25-page denial in January 2026, and his first substantive legal response, asserting he acted professionally throughout. And every factual denial is a document will be measured against whatever sealed discovery produces. And he locked in a sworn legal position. And the MSP lawsuit is coming, the defamation discovery is coming, and 5 murder defendants have Proctor's files. And 2 of his supervisors are named defendants in the federal civil rights case, and the second cop is still on paid leave and 7 months in with no end date. The sealed content doesn't stay sealed forever. It keeps getting described by more attorneys in more courtrooms before more judges until it doesn't just need to be described anymore. One sealed phone, 1 decade of data, 1 supervisory chain, and that received it casually. And the institutional collapse isn't coming, it's already happening, and we just can't see all of it yet. And if you think I'm right, the person who has been sending you Karen Reed updates for the last 3 years, they don't know half of what you just learned. Fix that.